can impact. So Nathan will be giving an overview, and then there are several workshop choices for during the workshop time. So without further ado, Nathan Eisenberg. Yay!
Well, thank you so much, and thank you for having me. I was hoping to have some exciting things about really positive things that are going on in the law, and be able to tell you about some exciting new cases. I'm a little worried about the direction some of these cases are going. Last year when I was giving presentations on developments in the law, were all good decisions and good positive developments. And I'm worried that the number of positive cases that we have going on is going to diminish substantially over the next several years. But on that happy note, let me point out that there are some good cases that have been decided that should affect many of the people in the room. First of all, as all of you know, when Scott Walker passed the right to work law, it dramatically affected unions in the state. Buried within the right to work law was a provision that doesn't get as much attention, but has been the subject of litigation that I've been handling on behalf of the machinists, and that's the dues checkoff provision in Act 1. And what that provision said is that members that have signed checkoff cards could revoke those checkoff cards on 30 days notice. Now, that was in the law, but it's totally preempted by federal law. And people that know the law very well knew that this provision would not be able to withstand a challenge in court, and it was a matter of time before we needed to challenge it, and that's what happened. So the DWD had been enforcing labor standards complaints. So if you had members that say, I want to get out of the union and I want the dues deduction to stop, they could go to the DWD and file a wage claim. Say, I want my dues back, and the DWD was enforcing that, even though the DWD has no right to do that. So we brought a case against the head of the DWD and eventually the head of the WERC, which is the agency that has the ability to interpret Act 1, and saying that this dues deduction provision is completely preempted by federal law. And at the end of December, between Christmas and New Year's, District Judge William Connolly here in the Western District of Wisconsin agreed with us and entered a permanent injunction of enforcement of this 30-day provision. Now, many of you will have members who are on dues checkoff, and those checkoff cards should say that members have a right annually to rescind their dues checkoff. So once a year, and it's typically triggered by the date that people sign the cards. And those provisions are still good. And dues checkoff and union security are not the same thing, and that's also important to know. So you're able to have people, even though Wisconsin has become the so-called right-to-work state, you can still have dues checkoff. You can still negotiate checkoff agreements of up to a year. So that 30-day thing, if you have an employer that you're dealing with and says, oh, people can get out on 30 days, it's totally wrong. There's a good case on point on that, and that's something important to know. But union security and dues checkoff are separate issues, and federal law is going to govern these dues checkoff agreements. And then in the last month or so, the National Labor Relations Board, an administrative law judge, also in a case involving the machinists in District 10, found the same thing. In that case, an employer went and they said, oh no, we've become a right-to-work state. We don't have to recognize the dues checkoff cards that have been signed in the past, and we're going to require that people be able to get out on 30 days notice. And the NLRB went to complaint on that, and a judge just recently issued a decision, again finding that the 30-day provision is preempted by federal law, and that employers can't force unions to go out and have everybody sign up again now that Act 1 has become law. So those are all sort of key things to think about. The other thing, and maybe this is more fundamental than these recent decisions, but that if you are in the private sector and you have members on checkoff, make sure you actually have the checkoff cards. Sometimes, and until Act 1 passed, this really wasn't such a huge issue, is people sign these cards 10 or 20 years ago in some cases. You need to have copies of those cards if you're checking off dues from those agreements. So it's really key that you still go through with the right paperwork and make sure that you're checking off dues based on a legitimate check-off card. And in addition to those dues check-off cases, I'll also mention real briefly, I'm also handling another case involving Act 10. I don't know if anyone is still representing employees in the public sector, but there is a case that's now pending before the Wisconsin Supreme Court involving the annual recertification elections. The WERC, after Act 10 passed, required that everyone file election petitions as a condition of having annual recertification elections. And they had a deadline for school district and state employees in September, so if you missed that deadline, they would automatically decertify unions. And a couple of unions, which I represent, missed the deadline, were automatically decertified. And we brought a case against the WERC saying that the law, Act 10 actually says that the WERC is required to hold those elections, that it's not discretionary, that they're required to hold elections, and based on the language in the statute, they couldn't summarily decertify people without holding the election. So that's a case that we won in Milwaukee County Circuit Court, we won in the Court of Appeals, but now the Wisconsin Supreme Court has taken up that case and it's currently in briefing. And if you know the composition of our Wisconsin Supreme Court, you might have some guess on how that might come out once they finally issue a decision. But it is interesting to know that there is still an Act 10 case out there sort of kicking around, which has been good so far. Let me also talk about some of the, another good decision that's worth knowing about is a decision from the National Labor Relations Board in a case called Browning-Ferris. This was a case decided in 2015 and was the oral arguments in the DC Circuit Court of Appeals were heard earlier this month. Many employers are using temporary services in whole or in part to staff their workforce. I know a lot of even union companies that I deal with use temporary agencies to get people in the door and for a period of time will have temps in the plant. And the ongoing battle that labor has always had about these temp agencies is it's very difficult to organize the temporary workforce. And the way that you can get at that issue historically has been to try and claim that the employer and the temporary agency are joint employers. And that's a way where you can extend the protections of union membership to these temporary employees. You can prevent them from undercutting the standards that you have in your workplace. And you can basically sort of hold the temporary agency's feet to the fire and make sure they're treating their employees fairly. Prior to 2015, there was a standard that in order to have joint employer, there had to be sort of direct and immediate control over those temporary employees. So it was often very difficult because you couldn't show that there was sort of this direct control that the temporary agency was exerting. So in Browning-Ferris, the NLRB issued a decision where the temporary agency and the employer share or co-determine control, that you can show a joint employment relationship. That's a much easier standard to meet because often the employer and the temp agency will have limited involvement depending on what the issue is. So once that standard is share or co-determine rather than direct immediate control, it's much easier to show joint employment. And that's, again, a huge tool when you're dealing with a workplace where there is a large or a growing contingent workforce hired by the temporary agency. So now you can claim that they were jointly employed and you can sort of rope in the temporary agency for that purpose. As I said, that case is currently on appeal in front of the DC Circuit. That's a pretty influential circuit when it comes to reviewing agency decisions. Go either way. We think the law on that is pretty good and that there's a good shot that they will uphold the court's decision. It's worth talking for just a minute or two about the NLRB. The NLRB, which decides unfair labor practices, representation cases, really is a body enforced or charged with enforcing labor laws in this country. And there's been problems over the last 10 years or even more in terms of getting the NLRB to function and to protect the rights of workers. During Obama's administration, there was a real problem on actually getting members of the board confirmed. So that Republicans had gone through this process of not confirming appointees to the agency. The agency didn't have enough members to issue decisions for a while. And it really has become dysfunctional in many ways. And you can only imagine how that's going to improve under Trump. Because we're going to continue to have problems staffing the agency. The silver lining to that situation is it takes the board a very, very long time to get to the point where they're going to make decisions. So there have been a fairly substantial number of positive, union-friendly, worker-friendly decisions that came out during the last 8 years. And it's going to take quite a while, even if the board had all of its members, and we don't anticipate that they're going to have all of their members all of the time. So even if they had all of their members, it's going to take a while for the board to get at some of those decisions and overturn or pare back the decisions. And that's the same process that we saw with decisions under Obama. During the last 2 or 3 years, we saw a lot more positive decisions than early in his term. So it really took a large portion of the 8 years to get at some of the really terrible decisions that were issued under the Bush board. So that's something that's worth considering, worth paying attention to, because over time it's going to change. And I don't think you're really going to see any major fights involving staffing the board or its appointments until towards the end of the year. The general counsel of the board, who is a former union general counsel, his term hasn't expired yet. It's not up until next year. So we think once we start getting into those appointments, where Trump is able to appoint more people to the board and to appoint the general counsel, then we're going to really see problems with good decisions that have been issued. And it really is interesting that over the last 8 years, we really finally have had a recognition of how antiquated some of the board's policies are and really bringing them into the modern age. It's interesting when you hear employers talk about that the board doesn't know the realities of the modern workforce, whereas when the board issues decisions that address the realities of the modern workforce, everyone says they're overreaching, or employers say they're overreaching. So it's going to be really interesting to see how that plays out, particularly given sort of the pressure to deregulate and defund many federal agencies. Speaking of federal agencies, as many of you know, the Department of Labor actually issued some helpful regulations for workers during the last several years. In particular, in May of 2016, the Department of Labor issued a final rule governing overtime. Many of you may have heard this. But when it comes to wage and hour issues, there's a number of provisions, or there's a number of positions and employees that are exempt from coverage under minimum wage and overtime statutes. The thresholds for determining which employees are exempt from overtime have not been updated in a very, very long time. This is another area where you had Obama-era agencies trying to update agency regulations that had not been changed in a very long time. And so one of the exemptions, which was applying to full-time salaried and professional employees, had a threshold of about $24,000 a year. So you could have people that were only earning $24,000 a year but may be exempt from overtime. And so the Department of Labor under Obama tried to create a new regulation that would up that threshold, and it was going to include some tremendous number of new employees who would then be eligible for overtime, would be able to get pay raises, be able to be paid for all of their hours of work. And as we now know, First of all, in November, a federal judge in Texas enjoined the overtime regulation from going into effect at all, so really prevented the overtime regulation from ever being applied. Apparently there's a single judge in a court in Texas who is sort of the go-to judge when it comes to enjoining federal regulations that help workers. So that judge blocked the implementation of the overtime regulations, and now under the Trump administration, I think there's a real question on whether they will continue to defend the regulation or whether they will give in, and what other options there are to enforce the regulation. The other problem is that the Trump administration could simply rewrite the regulation again and go back to the way it was. So those all create serious questions about whether or not the overtime regulations are going to survive. Obviously, most of you are not exempt employees. So why are we talking about these overtime regulations, the Department of Labor regulations? And there's a couple reasons for that. One is it really demonstrates how difficult it is for the federal government to update and modernize its regulations. If we're going to see either decisions from the National Labor Relations Board, decisions from the Department of Labor, these administrative regulations that take a very long time to go into effect, and all of them are now being challenged and many of them are being enjoined, that makes it really hard. And it also takes an incredibly long period of time for these regulations to go through the rulemaking process. To create an administrative rule, there needs to be notice, there needs to be opportunity for hearing, for consideration, and it's a very lengthy, time-consuming process. So if we're going to have to go through all of those processes simply to make incremental changes to regulations and then have them challenged in court, it's going to make it very difficult for any laws that protect workers at the Department of Labor or any other agency to ever get enacted. The other thing is overtime regulations also form sort of a tentpole. And so even if you are not exempt, if your supervisor is exempt and they're allowed to depress the wages for the supervisor, that creates a real problem and a real weird dynamic for many workers. And you have workplaces where people are being treated as exempt who really don't exercise those elements of control. And so when we're able to raise the tentpole for the exempt employees, that really has a benefit for hourly employees and all employees in general. So that's a really important modernization that was taking place that has really been negatively impacted by these legal challenges. As we're talking about regulations and the board decisions, I did want to briefly discuss some of the things that we've seen in the news in the last couple of weeks. Federal regulations that have gone through this rulemaking process often have the same effect as laws. So regulations by the Department of Labor and decisions by the National Labor Relations Board, you can often enforce those types of rights in court, use those as pretty good precedent. But you'll see, and you've seen since the beginning of the year when Trump was inaugurated, that you hear all of these news stories about regulations that are unilaterally being eliminated and decisions that are being revoked. So it's worth talking and thinking a little bit about how it is that the president is able to unilaterally act, the exact same thing he was complaining Obama was doing too much of. And there is a law that was passed as part of the Contract on America and New Gingrich. It's called the Congressional Review Act. And the Congressional Review Act has rarely been used until now. It was only ever used once when Clinton-era ergonomic regulations were rescinded at the beginning of the Bush presidency. And the Congressional Review Act allows regulations that were created in the last 60 legislative days. And so that's why we're hearing all about all of these regulations that Trump and Congress are unilaterally and rapidly revoking. And that's because of this Congressional Review Act gives them that right. That does only apply to regulations that were enacted at the very end of Obama's presidency. So some of the regulations that at the very, very end involving the coal industry that were passed, that's why they're able to get at those regulations, while as other regulations that were passed earlier in his presidency aren't subject to that Congressional Review Act. And so there have been some regulations in impacting labor that have been subject to the CRA. I saw some that talked about the OSHA silica standards that affects the construction industries, and I think that one's on the bubble, so I saw it both ways, whether or not it made it past or whether it was enacted before or after the cutoff. There's also some electronic filing and drug testing procedures that also fell within that 68 procedure, all of those which are now going to be considered by the Trump administration. In the same way that the Congressional Review Act allows administrative regulations to be rescinded, you're also seeing the president uses executive action and executive orders to rescind orders that were issued by president. And obviously, if President Obama issued executive orders that protects workers, and he did, and those can also be overturned by Trump by issuing his own executive orders. And that's a process that goes way back, because you saw Obama doing that in Bush-era executive orders, and Clinton doing that and so forth. So that's a long-standing thing. But that also means that if you're looking at regulations that affect you and that affect your members and affect other workers, figuring out whether this is an administrative regulation, whether it's a law, whether it's an executive order becomes really important. So as it appears now is that any executive order that would have protected workers are being rescinded by executive order. Anything that was enacted in the last 60 legislative days, and 60 legislative days would, as I said, go back to May of last year. All those regulations are now being carefully scrutinized. And we even saw this week that Trump was rescinding the Fair Pay and Safe Workplaces order, which prevented companies that contract with the federal government from being labor law violators. So for some weird reason, it might be a good idea to have labor law violators working for the government. I don't quite understand that. And they're also, he also rescinded some executive orders that prohibited contractors from discriminating on the basis of sexual orientation or gender identity. So I think what we're really going to see over the next 4 years is a real push for deregulation. Along with deregulation, any protections that can be taken away are going to get taken away. And then on top of that, sort of the third leg of that stool, is that there's going to be an overall defunding of these federal agencies. So anyone that might be a watchdog that could oversee protections, OSHA, EPA, I'm sure the NLRB is going to find its way into funding cuts. All of those things are going to be cut. It's going to make it much, much harder to get any agency to help protect the rights of workers. On a similar note, and I don't know if people have discussed this or not, but you're seeing that also that defunding and deregulation occurring at the state level. As part of the budget, and Mr. Barker might have mentioned this, there have been proposals to eliminate the Labor and Industry Review Commission, LIRC. And I'm sure anyone that attends the workshop this afternoon on workers' compensation will also hear this spiel from one of my partners. But LIRC would function as an appellate body for decisions on workers' compensation unemployment, so that would at least give people that got a raw deal or a defective decision from the administrative law judge hearing their case to appeal it to LIRC. And even though today LIRC is an agency that is controlled by Republicans, in the past it has been a body that has not functioned that way. And that by taking that step away, the appellate process, it really makes it much, much harder to challenge adverse decisions, adverse unemployment decisions, any decisions that would go up before work. And that also makes it much, much more difficult for workers to enforce their rights, to get benefits that they're lawfully entitled to. And that now means that things that used to go to work are going to go to political appointees who are, they're going to grant review if you win, but they may not grant review if you lost in front of the administrative law judge. So that's going to make things really difficult, and it's going to really force people to get to circuit court, which is a more expensive proposition. In addition to eliminating LRC, I saw there's also some proposals to eliminate funding for the Department of Workforce Development that enforces the civil rights laws. If you're not familiar, anyone that has claims for age, race, sex, disability claims, typically you would file that with the Department of Workforce Development as a prerequisite to bringing a lawsuit. And the DWD historically has been a place where you can actually get some investigation into those claims and find out about the claims and sometimes get resolution of the claims. But as that agency gets defunded and those rights become harder and harder to enforce, it really is a limitation on prohibitions of discrimination in employment. And so that's really, really troubling. And I also see that there's been some proposals to the legislature to also change the process in front of the DWD so that if a worker brings a claim to the DWD, they may end up owing the company's attorney's fees if they lose. So sort of a loser pays approach to enforcing laws, which is really horrible because that serves as a huge disincentive for people trying to enforce their rights not to be discriminated against at work. And now that's only the DWD. You still have the option to take those claims to the federal EEOC, which is a difficult agency to work with. That's a time-consuming process, and I feel like every time I file with the EEOC, it's complaints that go into a black hole and you may never hear from again. And so the DWD has been a much better process, a much more transparent process. But if these reforms go into law and as they get implemented, that might require rethinking on where those types of claims would go. And so those, I really can't overemphasize how disastrous that would be if you're no longer able to bring discrimination claims, enforce your rights through the state agencies to challenge unemployment decisions, because we all know the unemployment law has become much, much harder for workers that are laid off. And so now they're going to make it much harder to appeal bad decisions that you get at the lower levels. It's really a recipe for all sorts of pain for people in a situation where they're really not ready to have that level of pain. I think overall you're seeing sort of this push to unspool all of the legal protections, all of the safety networks, and all of the agencies and the watchdogs that should be helping workers enforce their rights. Which really means that we're at a stage where workers and their unions have to be particularly vigilant in enforcing their rights, and when there's situations where federal law is being violated, we need to challenge the state on that and to really pursue those claims in court. So on that happy note, that covers sort of the topics. I really, it was interesting when I was, those are the things I was sort of prepared to talk about, but I thought that when I came I'd have a little clearer picture on which direction some of these agencies were going to go and what that was really on their agendas. And I don't know that a lot of agencies are going to go. I find that really, really concerning. It's concerning not to know what's going to happen on the federal level with all these agencies, because we really have been able to rely, even if we couldn't rely on protections at the state level, because the state protections have been under attack for as long as Walker has been in office. But it's really concerning to then see sort of the floor that is set by federal law to also be under attack. And as I said, that just all presents a situation where we need to be particularly vigilant and to challenge where we have an opportunity to challenge. So I'm sure next time I come and speak, everything's going to be completely different. In addition to the joint employer lobby, or the joint employer ruling being challenged in the D.C. Circuit, the Deuce-Checkoff decision is being challenged in the 7th Circuit. The decision that my firm won in validating right to work is under challenge in the Wisconsin Court of Appeals. The Act 10 decision is being challenged in front of the Wisconsin Supreme Court, and the overtime regulations are being subject to challenge. So I'm not joking when I say that next time I speak, any one of these decisions could be overturned. So again, this is something that we'll need to keep a careful watch on. I'll put in a brief plug. A lot of these, as these updates occur, we're putting these on my firm's website and on our Facebook page. So if you're not paying attention to our Facebook page, maybe take a look, because as the decisions come out, we try to put them on there. So it's a good thing to keep up with, because I think we're going to see a lot of decisions that we may not like in the next year or two, but knowing the decisions, I guess, is the first step on how to challenge.
Do you have time for some questions?
I have absolutely time for questions, but I don't know anything.